I'm Linda Winsek Moore, Manager of Senior Services and Education here, in case for those who didn't know me. Today, we're lucky enough to have a distinguished speaker here. Welcome to the Senior Center, and our informational program today is criminal cases versus civil cases and legal terminology. Right there, I'm glad I could say that word, terminology. So please welcome the Honorable Daniel Wren, Associate Justice of the Superior Court. Honorable Wren will give a brief history of the Superior Court and highlight its history and the difference between Superior Court and other divisions of the trial court. He will also touch on the distinction between civil and criminal cases. And the question and answer portion will happen at the end of the program. So welcome, thank you. Let's give a round.
Good morning. My name is Daniel Wren. I'm a Superior Court judge. This is my excellent court officer, Lynn Early. It's a pleasure to be here. I was appointed to the Superior Court in May of 2011 by then Governor Deval Patrick. I grew up in Worcester County, graduated from St. John's High School. I left Worcester County for 4 years to go to Fairfield University down in Connecticut, attended Suffolk Law. When I got out of Suffolk Law in 1987, I took a job with a local firm called Milton, Lawrence and Dixon. I stayed with them for 24 plus years until in 2011 I was appointed to the court. So that's a brief history of my resume. The Superior Court is a circuit court. As a circuit court and as a member of a circuit court, I'm assigned to a particular courtroom, typically for 3-month intervals. So right now, beginning April, May, and June, I sit in a civil session in the Worcester Superior Court. I'm the only sitting Superior Court judge in the state who actually lives in the city of Worcester. So I typically sit in Worcester. Since 2012, with rare exceptions, I've sat exclusively in the Worcester Superior Court. Much like this facility, the Worcester Superior Court is the nicest courthouse in the state. It was opened in 2007. It truly is a beautiful facility. We have seven separate courtrooms, Superior Court courtrooms in the Worcester Court Complex. And there are 5 separate courts. There's Housing Court, Juvenile Court, Family and Probate Court, District Court, and Superior Court that sit every day in the Worcester Court Complex. The Superior Court in Massachusetts was founded in 1859 by an act of the legislature. Prior to that time, we did have a trial court in Massachusetts. It was called the Court of Common Pleas, and it started sometime in the 1700s. It was like the Superior Court, a circuit court. But in 1859, the legislature created what we now know to be the Superior Court. And at that time, there were 10 seats. So 10 judges covered the entire state of Massachusetts. In a circuit basis, they rotated to different locations in the state from sometimes month to month, sometimes a series of months, but it was a rotating court at that time, and they handled everything. So now, flash forward to 2024, the Superior Court has 82 seats. So each county, depending on its size, Worcester has 7, Springfield has 7, Middlesex, I think, has somewhere around 10 or 12. Suffolk is the biggest. It encompasses Boston. They have double-digit courtrooms as well. But some of the other counties, the smaller counties, might only have 1 judge sitting in that particular location. The other courts the specialty courts have developed over time to meet the needs of our community as we evolved into a more industrialized economy and society. We needed more specialized courts. So we developed things like Housing Court, Family and Probate Court, Land Court, Juvenile Court. So their specialized jurisdiction limited jurisdiction to hear only particular cases. For instance, in housing court, because housing is such a time-intensive circumstance, if you're getting evicted, you can't wait weeks or months to get your case heard. You got to have an area that can go in, specialized knowledge, and get the case heard right away. So over time, the court has evolved to meet the needs of a growing and changing society. Superior Court and District Court have a lot of the same general type of cases, but there are distinct differences between the two courts. District Court or municipal courts, Worcester District Court, Dudley District Court, Westboro District Court, they hear all criminal misdemeanor cases and all civil cases with a value of $50,000 or less. They send, in criminal matters, they can send defendants to the various houses of correction, that is, county jails. And again, their civil jurisdiction is limited to cases that have a value of less than $50,000. As you might imagine, because they're doing misdemeanor crime, they're very busy. So probably 90% of their volume is criminal matters, and it's a high volume of cases coming in because, again, it's mainly misdemeanor crimes, including traffic offenses and things like that. Superior Court's jurisdiction is two-pronged. We hear both civil cases and we hear criminal cases. Superior Court judges are the only judges in the Commonwealth that can send defendants to state prison. So any felony criminal matter that carries a potential state prison term has to come to the Superior Court. The major difference is if you bring a case in the district court, any one of you as citizens of Massachusetts could go down to the district court, swear out a criminal complaint under oath, and go through a process to have a criminal complaint issued. Just by way of example, if someone were to assault you, you could go down to the district court, swear out a factual complaint, and the district court would issue a criminal complaint against that defendant who would have to come to court to answer to that crime of assault and battery, which again is a misdemeanor. In order for a case to be filed criminally in the Superior Court, it has to be indicted. An indictment is issued only by the grand jury. A grand jury in Worcester County, and really most counties in the Commonwealth, sits for a period of 3 months. So it's quite a commitment for citizens who have to sit as grand jurors. They're presented with case facts from a district attorney or an attorney general, and they determine whether a case should be indicted. We call it a true bill, but whether an indictment should issue. When an indictment issued, then the defendant is indicted in the Superior Court. They're brought before us, and again, we hear all felony matters. Our case volume is much lower than the district court on the criminal side, but that's because there's a lot less felonies, but they tend to be more serious. So our trials, most of the district court trials are maybe a day, half a day, maybe 2 days. Our cases tend to be 3, 5, maybe a week or longer, depending on the magnitude of the crime involved. On the civil side of the docket, we hear all cases that have a value above $50,000. So again, we hear the more serious civil cases. We also have jurisdiction over any land disputes, any administrative, if you go through a process with your local city or town and you're not happy with the result that you've reached, you've ever gone through a licensing issue with the Registry of Motor Vehicles, if you're not happy with that, then you have a right to come to the Superior Court for a review of that decision. So that's a general outline of what the Superior Court is versus the District Court, and a general outline of what the various courts are and how they've evolved over time. The process of becoming a judge, Massachusetts, pursuant to our Constitution, affords the governor the right to appoint judges. So unlike a lot of states where they have elected judges, we follow the federal model, which is the governor of our state appoints judges. The judges are then put before an entity called the Governor's Council. In this county, Paul DiPaolo is our governor's counselor. There are 8 governor's counselors around the state. They divide the state geographically. And as a potential judge, once you're appointed by the governor, you fill out another application. You go before the governor's council for a public hearing, and then they vote on whether to confirm you as a judge. So the process of becoming a judge is fairly lengthy. You fill out an application. I know back when I did it in 2010 is when I filled out my application. It comes out to maybe 40 or 50 pages. It's got a lot of information in it. You got to give them, your whole history. You got to give them samples of cases that you've been involved in. And you present that to what's called the Judicial Nominating Commission, the JNC. That's a panel of about 25 to 30 members of the community appointed by the governor. And that body's role, mainly lawyers, some retired judges, but there are folks in the community, lay people who are on the committee as well. Their role is to vet the particular judge. So you provide your application to them. They select maybe 5 or 6 members of the JNC to read over your application and decide whether you get an interview. So you get an interview, you drive into Boston. Now they probably let you Zoom it, but when I did it, you had to actually drive in. So you go into Boston and you appear before, I appear before the full JNC. You go into an office in Boston, and then they ask you questions for about a half an hour or so. Depending on what happens at that interview, you then are put forward to go to what's called due diligence. Then they appoint 2 members of the JNC to contact folks in the community, your neighbors, people you work with, people in the court system. They run your background to see if you've got any criminal matters. I had no criminal matters. And to see if you have any parking tickets. I had a lot of parking tickets, but I paid them off. And so you go through this vetting process. They talk to lawyers who you've had cases with. They talk to judges who you've appeared before. They talk to people like Lynn, the court officers, to see how you treat them when you go to court as a lawyer. It gives them insight as to how you might treat people when you're a judge. They then make a recommendation as to whether you're qualified. You're then submitted to the governor. Once you're in the governor's office, you meet with the governor's chief legal counsel. Again, 20, 30-minute interview. He or she asks you some questions meant to get a sense of who you are, how you interact with people. And then the governor makes a decision to appoint you. There's yet another committee you have to go through. It's called the Joint Bar Committee. The Massachusetts Bar Association appoints members to the Joint Bar Commission. They're all lawyers from various parts of the state. I honestly don't know how many there are. My guess it's in the 6 to 8 range. Worcester County has a delegate that's part of that, and they vet you again. So they put you through another vetting process, and they make a recommendation to the governor. You're either not qualified, qualified, or highly qualified. If they determine that you're not qualified, the governor can still appoint you to the bench, but that committee's recommendation is made public. So in the history of the JBC, no judge has ever been appointed where the JBC said they were not qualified, because no governor would take that risk that they've appointed a judge that was deemed unqualified. If you're deemed qualified or highly qualified, you as the candidate are never told what that distinction is. That distinction is given to the governor. Then the governor will appoint you typically. At that point, your next step will be to go to the Governor's Council for the confirmatory hearing that I talked to you about earlier. So that's what I have for you this morning. I'm happy to answer any questions that I can, so I guess I'll open it up. That's it? I can grab my corn and leave? Yes, ma'am. That's correct. Sure. So in Massachusetts, there are various statutes that afford people the right to a trial by jury. There's also constitutional components that afford people a right to a trial by jury. On the civil side, in broad strokes, equitable claims versus legal claims. Legal claims are typically things that involve money damages. In legal claims, you have a right to a trial by jury. In equitable claims, like if I'm trying to enjoin you from coming onto my property, or if I'm trying to get money back from you because I say you unjustly took it from me. Those type of equitable claims traditionally are not jury claims. And in a lot of matters that the legislature, you've all heard of Consumer Protection 93A claims, those you do not have a right to a jury trial. So by and large, that distinction on the civil side is determined either by the Constitution or by statute. And generally, if you're looking like if you got hit by a car, you got in a car accident, you fell on property, those you have a right to a jury claim. Now, even in those cases, the parties, you have to claim the right to trial by jury. So when you file the claim, you have to claim a right to trial by jury. If you don't do that, you're deemed to have waived it. So in civil cases, I'd say 70 to 75% of the cases are jury, 25 to 30% are non-jury that I hear. And I've tried going on 300 cases over my time as a judge, so those are probably what my numbers look like. On the criminal side, criminal defendants have a right to a trial by jury, and it's a right to a trial by jury of 12 members of the community. So they can waive it, and sometimes they do, but I'd say on the criminal side, it's more like 90 to 95% are jury, 5 to 10% are jury waived. You know, there's reasons on the criminal side at times to do a jury waive trial. If you've got a very technical defense, legal defense, that you're kind of hesitant about a jury, not that they can't understand it, but it's harder to present that in a jury setting to 12 citizens who aren't trained in the law, you know, than it is to a judge who at least understands the issue that's highly technical. But that's a general outlay of how we go about it. Yes, sir. Yeah? So in Worcester County, we seat a grand jury the first Monday every 3 months. So we sat one in January. I think I impaneled that. We sat one in April. I think I impaneled that. So usually in our courthouse, courtroom 20 is a civil courtroom. That's where we hear civil matter. That's where I'm sitting right now. And the grand jury is right near where that courtroom is. So it's convenient. So we bring the grand jurors in, we give them the presentation to be selected. So I'm not selected to do it. I've done it a lot over the years, so if I'm available, I'll do it. But any judge in the Superior Court can impanel a grand jury. Yes. Yep. Yep. Yes. Sure. So what you're talking about is every civil case that's filed in Superior Court is given what's called a tracking order. So when I first became a lawyer back in the 80s, there were no tracking orders. So you'd have cases that would sit literally forever. We'd have these, what they call them strangulation lists. And as a young lawyer, my senior people would say, go down to the Superior Court and be there for the strangulation list. Here's our list of cases. Because they were just sitting around. They didn't have any order to them. They call them, most of them were dismissed. And, the dockets became unwieldy. One of the chiefs of the Superior Court, Barbara Rouse, she was my first chief, she implemented the tracking order system. So every case that's filed, the clerk's office issues what's called a tracking order. And the order sets up time intervals for things to be handled in the natural course of the case. And the tracking orders have a fast track, average track, and then I forget what the last one is, but it's a longer track. It gives kind of benchmarks of when we expect things to happen. And in the computer age, if they don't happen, it sends out a tickler to the clerk, get the lawyers in here so we can get this case back on track. It's a management system to make sure that cases don't linger. And I'll just give you, back in the early 2000s, in the old courthouse, we had 3 civil sessions, 2 criminal sessions. In 2007, the new courthouse opened. We had 4 civil sessions, 3 criminal sessions. So we picked up a civil and a criminal session. But back then, in the early 2000s, each criminal session had about 1,500 cases in it. That's a lot. Now, a civil session runs between 550 and 650 cases number. It's a very manageable number because most cases on the civil side resolve between the litigants. We're there to give them a trial if they need it. 90% of the cases settle. So the numbers have come under control in large part due to the tracking order system that you asked about. Yes. No. So when you file a civil case, you fill out a form. What would a court be like without a form? So there's a form, and you check off what type of case it is. And the clerk's office has a list. And if you're in this case, if the case is this type, history tells us it's going to take 2 years to resolve. History tells us it's going to take 4 years to resolve. So depending on the type of case, that'll dictate what track you're in. Now, you could be put in the average track, for instance, and you could come into the court and say, listen, the 2 lawyers have talked. We think we're going to need more time than that. This is very usual. And we'd say, okay, how much time do you think you need? If it's reasonable, we give it to them. So these are not draconian time periods. We still want the lawyers and the litigants to manage their own cases. We just want to make sure we know where they are. And at some point, if it's too long, we say, well, we let you manage it for a while. You're not doing a good job. So we have to become more active in getting this case to resolution. So they're more guidelines than real orders. We're trying to just move people along. You're welcome. Yes. So there are a lot of different circumstances where that happens. One such, which may be applicable, I don't know, but let's say you're out working for a construction company at a job site. You're working as a subcontractor doing flooring, for instance. There's a general contractor who's responsible for the overall management of the projects. You're doing the flooring, you fall through a hole, you injure yourself, you've got medical bills. You'd be on what's called workers' compensation. So your workers' compensation would pay your medical bills and give you 2/3 of your average weekly wage until you're able to go back to work. And that's given to you whether it was your fault or not. So it could have been a hole you saw and you just were careless, walked into it. You're going to get workers' compensation. The idea being we want people who are injured at the job to be able to keep their net salary. That's why it's 2/3, because workers' compensation isn't taxed. So the third that they're taking out represents what would have been tax payments. So you're essentially, the idea is you're netting out your weekly pay during the period that you're injured and recovering, and your medical bills are paid. Well, let's say you as the worker say, well, It wasn't my fault. It was that general contractor who didn't cover the hole properly. That's why I fell. So I want to sue them. You can do that. Now you come to Superior Court for a lawsuit. Well, now you have to prove fault. You have to show that the general contractor was negligent. Now, in fairness, if you recover money against the general contractor, you shouldn't keep it all because you've already had your medical bills paid and you've already had your wages paid, at least to some extent. So the insurance company that paid the workers' comp money says, we want that money back. We have a right to get that money back. So before that case can be settled in Superior Court, we hold a hearing where we bring the injured party in, we bring the defendant general contractor in, and we bring the insurance company for the flooring company that comes in and says, hey, we want to be heard on how you allocated the monies in this settlement. So yes, in that instance, you have to have a hearing, and a judge will have a participatory role in determining whether the allocations that have been made are appropriate. Now, I will tell you that 95% of the time when I get involved, it's to say, everybody agrees? Yes, we do. You guys all know this is it. No more coming back to the court. We're done with this case. It's over forever. Yes, approve. So it's not usually a contested hearing. Any other questions? Yeah? No. So criminal cases are not subject to mediation. They are subject to negotiation. As a criminal defense lawyer, you would talk to the district attorney about a plea. I'll plead guilty. What would be my sentence? And there's some negotiation there. Judges get involved in that once that's finalized. So I can take a plea. I take a defendant through a lengthy discussion or colloquy on the record to make sure he's making or she's making a knowing and voluntary decision to plead guilty. On the civil side, so when I was a lawyer, for 10 years of my practice, I served as a mediator arbitrator. So I did a lot of mediations. Mediation is a voluntary agreement by two sides to come before a mediator to get input. So typically what I would do, I'd meet with the two parties in a room. They'd tell me what the general parameters of the case were, and then I'd separate them. And I'd go from room to room to try and take what was, it's always about money. So, the plaintiff wants lots of it, and the defendant doesn't want to pay any of it. So my role was to get them to come together. It was a successful mediation if I sent them both home with a settled case and they were both unhappy. So that means I did my job. They took a number. I got the insurance company to pay more than they wanted to, and I got the plaintiff to take less than he wanted. So that's the process. It's voluntary. You can walk away at any time. The difference between arbitration and mediation, arbitration is a binding process. So when I served as an arbitrator, they'd come before me, and I would decide who was at fault and how much money it was worth. So that one, you have less control as a litigant. Mediation, you have a lot of control as a litigant. We used to say to people, there's no reason not to mediate. You don't like it, you can just get up and leave. You've got someone who's willing to pay you money, that's what you want. You've got someone who's willing to take your money, that's what you want. If you can't work it out, fine, but at least talk to one another. Arbitration is different. You're giving up your right to a trial in whatever court you're in.